joining us right now is one of your colleagues over at Breitbart. In fact, he's the senior legal analyst for Breitbart News and on faculty at Liberty University School of Law. He's been covering the Supreme Court for 5 years. He's Ken Klukowski. And actually, by the way, he's been appearing with me on the radio for about 4 of those 5 years. Ken Klukowski, Happy New Year, sir.
Larry, Happy New Year to you and to you, Kerry. Great to be with both of you.
So, Ken, it was a big year, a very big year in the Supreme Court rulings last year, and I think everybody, of course, wants to immediately go to the Defense of Marriage Act and the court striking down Prop 8 in California. But I'd first like to talk about the ruling that was handed down the day before that, on June 25th, and that was Shelby County v. Holder. That was a pretty major decision as well, was it not?
Absolutely. That was a big win. It's regarding the Voting Rights Act, where in the Voting Rights Act of 1965 has 2 big provisions. This law was authorized by the 15th Amendment of the Constitution after the Civil War to protect voting regarding racial issues. And Section 2 applies nationwide, and that is that it is illegal for anyone in government to deny anyone's voting rights because of their skin color. But then you also have Section 5. The idea in the 1960s was that some parts of the country had such rampant voter suppression on the basis of race that if you wait until it happens and someone sues, that person would not have their rights restored by Election Day. And so the idea was that for those areas, they couldn't change anything about their voting laws, even the color that their ballots were printed on, without first going to the U.S. Justice Department in D.C. and getting permission. The issue that was decided in Shelby County is that you had before the court was the whole issue of this Section 5 pre-clearance system. The court, everyone was wondering whether the court was going to uphold or strike down Section 5. Instead, they went in a different direction, saying we're leaving pre-clearance in place, but we're striking down another part of the law, Section 3, which is the formula that Congress developed to determine what states or areas are in Section 5, because Section 3, which includes mostly southern states, is all based on data from the 1960s or 1970s. And the Supreme Court noted that today, the worst state on racial voting issues, the worst statewide case, would be Massachusetts, which is far in the north and which has a black governor.
And could do whatever they wanted without getting the Attorney General's permission.
So the Supreme Court said that the section, in a 5-4 decision, that Section 3 is no longer rationally related to modern data, struck it down, and told Congress to come up with a new system, which they haven't done yet. Now, Justice Thomas said, I don't think Section 3 goes far enough. I think Section 5 has seen its day. It is no longer proportionately related to modern America, and that the whole pre-clearance system should be shut down. Justice Thomas, I think, has been proven correct because right after Section 3 was struck down, Attorney General Eric Holder started suing southern states to force them back into pre-clearance, like Texas, without any formula from Congress. If Section 5 had been struck down, that wouldn't even be an issue right now. Instead, we're back in court.
Ken, it's interesting because you have the liberals who for so many years have always focused on Section 5 of the Voting Rights Act. But if you also look at, say, Section 8 of the National Voter Registration Act, and this particular section looks at making sure that the voter rolls are clean. That never seems to get enforced.
Right, which really affects the voting outcome in many cases.
Right, and J. Christian Adams is really out there making sure he's actually looking at cases, and he is out there fighting to make sure that come the upcoming elections, as well as 2016, that the voter rolls in a number of counties are going to be clean. Can you talk about that?
Absolutely, and in fact, Christian is pursuing a number of those cases, got an early win in one of those cases. These are the first cases of its nature. I've never seen litigation like that being brought before, and it was just launched this past year, and it's having success in some quarters. I have to say, regarding, I think the bigger, and that is motor voter, and that's what we're talking about here, is a huge issue in that regard. The Voting Rights Act of 1965 is even much bigger, and I think based on what Eric Holder is doing now, trying to force states back in it, I wouldn't be surprised if Justice Thomas proves to be prescient that maybe not in 2014, but before the 2016 presidential election, I wouldn't be surprised if the Supreme Court has to revisit whether the Section 5 pre-clearance system makes any sense in America anymore. We have to note Section 2 remains in force. It will always be illegal to infringe someone's voting rights based on their skin color. The only question here is whether some sovereign states cannot be on equal footing with others, that certain sovereign states who traditionally control their own election systems must instead go with hat in hand to Eric Holder and get his permission before they change the color of their ballot.
By the way, important to note that in Hillary Clinton's very first major speech that was sort of seen as her coming out and testing the waters for the 2016 presidential bid, this was the main focus of that speech. So this will be a hot issue going forward, even though it was a decision from last year. Let's pivot to some of these decisions we should look forward to coming up. Most specifically, Ken Klukowski, what will the Supreme Court be hearing with regard to Obamacare coming up in 2014?
Well, I think, first of all, the Supreme Court has already agreed to hear a challenge, two challenges, in fact, on the HHS mandate. This is a regulation from Kathleen Sebelius that compels all employers, almost all except for churches, to provide birth control and abortion-related services in health care to their employees. The Supreme Court is taking up two of those issues. Obviously, Catholics and evangelicals and Mormons are all up in arms regarding this issue, and I am confident that by at least a 5-4 vote, and probably only 5-4, the Supreme Court will hold that this regulation violates. They probably won't get to the First Amendment of the Constitution because there's actually even a federal law that Congress passed called the Religious Freedom Restoration Act. And this regulation from the Obama administration, which is just a war on Catholics and people of traditional faith, I believe will be struck down. That issue is going to go forward. There is also a major challenge regarding IRS subsidies being extended to millions of people not authorized by the Obamacare statute, by the Affordable Care Act. That issue, I believe, will also be in court, though it won't be at the Supreme Court in 2014.
And what about going forward, the issue of same-sex marriage? I mean, what's on the horizon there? We already saw a Utah judge put his opinion in on this, as well as issues going forward with polygamy.
Right, basically saying, following exactly what conservatives argued, which was, listen, if you don't draw the line here, where do you draw the line? Utah judge says, well, based on the same-sex marriage ruling of last year, I don't see how polygamy is a problem.
That's right, and you got two U.S. district judges, both in Utah, who 1 week apart, one declared a constitutional right to gay marriage, and the other declared a constitutional right to polygamy, to marry more than one person at a time. And there is a consistency between those two. You're right. This is what conservative lawyers have been arguing for years. If you redefine marriage, and for 5,000 years, marriage laws have all been about one thing. It's been about children. They've just reflected the biological reality that every time a child is born, it's as a result of sexual activity between two persons, one a man, one a woman. Marriage laws, set aside all the religious aspects, marriage laws are designed to bind together that man and woman to provide a stable social structure for the protection, nurturing, and raising of that child, because every civilization has a vital interest in having a successful next generation. Once you redefine marriage to be about emotional fulfillment and happiness and companionship, right away you say, well, then they don't have to be opposite sex anymore, but you also say, well, it can be more than two people.
Ken, we got to roll on that. It's great to hear from you, as always. I always feel like I want to talk to you for a few hours, so we'll have you back. In fact, I want to talk about the upcoming decisions over the NSA and the Fourth Amendment, too, but we're just out of time.
Absolutely.
Happy New Year, Ken.
Happy New Year to both.